All right, welcome. Today, we're going to break down a really powerful legal strategy you can use against debt collectors. Seriously, if you've ever faced a lawsuit over an old debt, you're going to want to stick around for this. We are going to walk through how you can take back control of the situation using a tool you probably don't even know you have. Okay, let's just dive right in. It's a pretty strange and, frankly, scary experience, right? You get a summons from some company you've never heard of, something like LVNV Funding or Midland Credit Management, and it's about a credit card debt from years ago. Well, this is a classic move by what's known as a junk debt buyer. But what if I told you that the key to your entire defense wasn't some complicated, hard-to-find legal argument? What if it was actually tucked away in the very contract they're trying to use against you? A contract they were forced to take on, along with all of its original rules. Okay, so first things first. If you're going to beat them, you have to understand their game. You see, their whole business model is built on one thing: volume and speed. It is not built on winning tough, drawn-out legal battles. Here's how it works. They buy up these huge portfolios of old, charged-off debt for, and I mean this literally, pennies on the dollar. Then they just flood the court system with lawsuits. They're basically banking on the fact that most people won't respond, either because they're confused or intimidated. And when you don't show up, bam, they win a default judgment automatically. It's a pure numbers game, and they're betting against you. So now that we get their playbook, let's talk about how to completely and totally disrupt it. We are going to take their high-volume, low-cost strategy and flip it right on its head. And here is the big counter move. Instead of getting into an argument about if you owe the money, you change the entire argument to where this dispute should even be heard. The whole strategy is to file a legal document called a motion to compel arbitration. And you gotta understand, this is not just some defensive tactic. It is a powerful offensive move. By forcing the case into a different venue, private arbitration, you fundamentally change the entire economic landscape of the fight. You put all the pressure right back on the debt collector. So how is this even possible? Well, it all comes down to two really powerful legal principles. And they're probably buried deep in the fine print of that original credit card agreement you signed way back when. So this whole thing is built on a concept called successor liability. The easiest way to think of it is this. When the debt buyer bought your debt, they didn't just buy the right to collect money from you. No, they bought the entire contract. That means they inherit not just the rights, but all of the original company's obligations too. And that leads us right to the second principle, assignee estoppel. This is a fancy legal term that basically says you can't have it both ways. They can't cherry pick, use the contract to sue you, but then ignore the part of that same contract that says all disputes have to be handled through arbitration. Nope, they have to take the whole deal, the good and the bad. So let's just break that down real simple. Successor liability establishes that the debt buyer is now the new party to the contract. Then assignee estoppel steps in and holds them to all the rules of that contract, especially the ones they would much rather avoid, like a super expensive arbitration clause. And look, this isn't some weird, fringe legal theory we're talking about. This is backed by the full force of federal law. The Federal Arbitration Act, or the FAA, creates a very strong national policy in favor of arbitration. And the Supreme Court has upheld this again and again. What that means is, once you show the judge that a valid arbitration agreement exists, their role is pretty simple. Enforce it and get the case out of their courtroom. But this strategy, it isn't just about legal rules. It's real power. Its real teeth comes from leveraging cold, hard economic reality right back at the debt collector. So here is where the strategy really starts to bite. A standard lawsuit, that might cost the debt buyer a couple $100 in filing fees. It's nothing to them. But private arbitration, that can cost thousands in filing fees, administrative costs, and paying for the arbitrator's time. You are single-handedly changing their cheap little bet into a very, very expensive problem. How expensive are we talking? Well, the hourly rate for a private arbitrator can easily be $400, $500, even $700 an hour. You want to hear the best part? Under the terms of most of these original contracts, the company that's bringing the claim, in this case the debt buyer, has to pay for most, if not all, of that bill. Just put yourself in their shoes for a second. If they're trying to sue you for a $2,000 debt, but it's going to cost them $5,000 just to get the arbitration process started, what do you think they're going to do? It becomes a simple business decision, and you've just made pursuing you a very, very bad one. Okay, so this all sounds great in theory, but what does it actually look like in practice? How do you do it? Let's walk through the 5 essential steps to pull this strategy off. All right, let's go through it. Step 1, you've got to find that arbitration clause. It's usually in the original credit agreement. Step 2, you file the really important documents with the court. That's your answer to the lawsuit and the motion to compel arbitration. Step 3 is absolutely crucial. You ask the court to stay or just pause everything. Step 4, you need to show that you're acting in good faith and that you're actually ready to arbitrate. And finally, Step 5, be ready to argue your case, using the FAA and those legal principles we just covered to shut down any opposition. And this is exactly why this whole thing matters. The law is set up to ensure fairness and continuity. So when your debt was sold, your original rights and protections, and that includes the right to arbitrate, were sold right along with it. The debt buyer is legally bound to honor them. Period. So what's the big takeaway from all this? It's that by understanding the rules that the debt collectors themselves are forced to follow, you can literally transform their own legal paperwork from a weapon they use against you into your most powerful shield. The answer might just be sitting right there in your old files, just waiting for you to use it.